Okay, sedia. Bismillah, alhamdulillah, wassalatu wassalamu ala rasulillah wa ala alihi wa sahbihi wa mawala. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Inshallah, for today, my provisions are section 106 to 112, examination of witness. My name is Muhammad Shukri bin Shamsul Anwar, 117 to 746. Okay, let's go to the explanation of my provisions. Section 106. Where a witness has answered any question which only tends to shake his credit by injuring his character, no evidence shall be given to contradict him. However, if he answers falsely, he may be charged with giving false evidence. Section 107 deals with the exceptions to the general rule that a party cannot cross-examine his own witness. If the party cross-examine his own witness, his sworn statement will be considered as irrelevant and negligible. In order to cross-examine your own party, you must first get consent from the court. Section 108 deals with impeaching the credit of a witness by three methods. First, unworthy of credit. Second, bribe or induce. Third, inconsistent statement. If one of these three things occur, then you can impeach the credit of the witness and treat him as a hostile witness. Section 109, for the purpose of corroborating the evidence of a witness as to any relevant facts, he may be asked of questions of other circumstances observed by him at or near to the time or place at which such relevant fact occurred. Section 110, the formal statement of a witness may be proof to corroborate the present testimony relating to the same fact. And if the formal statement is inconsistent with the present testimony, we can use section 108 in order to impeach him and make his statement irrelevant or negligible. Section 111, it mentioned about section 20 and 21, and section 20 and 21 enumerate a long list of type of qarina which are admissible in the court. If the particular qarina is admissible in the court, then only the qarina can be either contradicted or corroborated according to section 111. Section 112, a witness may refer to a document that is produced either by him or by another person when giving his statement in the court. However, he must first get consented by the court. Okay, let's move to the next segment, which is Sharia perspective. I have two main topics here, which is first Tazkiyah Ash-Shuhud, examination of witness, and second is Ash-Shahada ala Kitabin Matbu', statement based on a document. Okay, Tazkiyah Ash-Shuhud. Tazkiyah Ash-Shuhud has been outlined by Islamic scholars in their manuscripts. Therefore, I will explain the steps that we outlined by them. First step is, after hearing the witness statements, the judge will instruct his writer or his assistant to write down the details of the witness, the statement of the witness, and the adverse party details. After that, the judge will instruct a group of persons. We call them al-muzakki. They will go to the witness neighborhoods or witness village, witness housing area in order to inquire the neighbor, the family, the friends, to determine whether the witness is credible or not. If after that, they will return to the court, and then two persons from the group will be called by the judge. If both of them agree that the witness is credible, the witness statement will be accepted. If not, it will be rejected. However, if they contradicted whether the witness is credible, one said the witness is credible and one said the witness is not credible, therefore a third person will be called, and the third person decision will determine whether the witness statement is rejected or not. Okay, let's move to the next topic, which is Shahada ala Kitabin Matbu'. It is based on this. It is related to section 112 clause 1. A witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of transaction concerning which he is questioned. Az-Zuhaili stated that a witness may deliver statement by conveying his agreement or disagreement towards the content of a document that is prepared either by him or by the court. However, some scholars opine that the document must be read while some said it is not needed for the document to be read during the trial. Let's move to the next segment, which is comparison with Evidence Act 1950. As we should know that Evidence Act is quite similar with Sharia Court Evidence Act. Why? Because most of the Sharia Court evidence enactments or statutes were drafted by using the Evidence Act as a main benchmark. That's why the most provisions are in pari materia with the Evidence Act 1950. But however, I found two minor differences, which obviously first is number of provisions, 106, 112 for the Sharia Court, 153 to 159 for the Evidence Act. Secondly, term use in the section 111 and 158. Qarina for Sharia Court and proper statement for EA, Evidence Act. However, they only differ in terms. In the meaning, it's still same, it is similar. The next segment is comparison with Brunei, and the chosen statute is Brunei Sharia Court's Evidence Order 2001. Okay, so the comparison is quite similar with the previous comparison. The first is number of provisions, 106, 112 from Malaysia, 134, 141 from Brunei, term use in section 111 and 140, Qarina from Malaysia, proof statement from Brunei. And still the concept, the meaning, then the scope is still quite the same in both jurisdictions. Okay, the next segment is related cases. I will review 3 cases for you. Okay, first, Tai Kian Hock against Kewangan Bersatu Berhad, section 106. The plaintiff denied that he had any relationship with JL Technic or that he was in possession of the premises or using its machines. Defendant could contradict the plaintiff, but not to injure his character, but to prove a fact in the case. Therefore, explanation 2 of the section 106 applied here. Second case is public prosecutor against Sarah Ravindran, section 108. A witness was challenged by the DPP regarding his whereabouts during the incident. DPP alleged that it is inconsistent with his previous statement in the police report. Therefore, the witness can be treated as a hostile witness. Then the third case is Muhammad Zakwan Jainuddin against PP, section 110. Police report lodged by the victim acts as a piece of corroborative evidence in the rape case. In the police report, she had told in detail the ordeal that she had suffered on the hands of those 6 men. Okay, let's move to the last segment, which is my personal views in regard with these provisions. If I am a legislator, I would like to draft a bill to add some provisions that will include the procedures of examining a witness, which is Tazkiyah Ash-Shuhud, as shown in Brunei Sharia Court Evidence Order 2001. Yeah, I know we have theoretical part for the evidence laws in detail, as we have seen in Sharia Court Evidence Act and also in Evidence Act. But I opine that we are still lacking in the procedural laws for the Evidence Act. So I think maybe we should add some provision to strengthen the principle of the examination of witness in our laws. And my opinion also is we lack the procedural laws of provision in regard with examination of witness. If a systematic and detailed procedures are added to our related statutes, it could guarantee the credibility of a witness, thus avoid the false statement from being produced in a trial. That's all from me. Thank you for lending your ears. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi ta'ala wabarakatuh.